Good afternoon, everyone, and welcome to the webinar, Treatment and Care of People with Drug Use Disorders in Contact with the Criminal Justice System, Alternatives to Conviction or Punishment, Impact of COVID-19 in Africa and the Americas. An event organized by the United Nations Office on Drugs and Crime, UNODC, in cooperation with the African Union Commission, AUC, and the Executive Secretariat of the Inter-American Drug Abuse Control Commission. My name is Pamela Westphal, Project Officer of the Institutional Strengthening Unit of CICAD OAS. It is my pleasure to be here. Before starting this virtual session, I would like to inform you of some in-house logistics. Kindly note that this webinar will be held in English. However, simultaneous interpretation is available in Arabic, French, Portuguese, and Spanish. To activate the language of your preference, please click on the interpretation button at the bottom of your screen. For Arabic interpretation, please use the Russian label on the interpretation channel. At the end of the presentations, we will have a 20-minute question and answer period, time permitting. Therefore, we welcome participants to submit their questions using the chat button at the bottom of your screen throughout the course of the event. If your question is addressed to a particular panelist, please make sure to address them in your question. Lastly, in case you lose your connection, we invite you to use the same link with which you accessed the session in the first place. That said, I have the honor to introduce our moderator for today, Ms. Giovanna Campello, Chief of the Prevention, Treatment, and Rehabilitation Section of the United Nations Office of Drugs and Crime. Ms. Campello, the floor is yours.
Excellencies, dear colleagues and friends, it's a great pleasure for me to be your moderator today at this webinar, which has been organized by many people as at the Prevention, Treatment, and Rehabilitation section of the United Nations Office on Drugs and Crime, our colleagues in the Justice section, the colleagues in the African Union Commission, and the colleagues at the Executive Secretariat of the Inter-American Drug Abuse Control Commission. It is a bit of a mouthful, so we use the Spanish acronym of the Commission, CICAD. We have our respective leaders with us today to open the webinar officially, but I hope you will not mind for me to add my heartfelt welcome and thanks for being with us today. This is one of the most important initiatives we have launched recently, and it is incredibly exciting to move the issue of alternatives forward in such an international dialogue. Without much further ado, it is my great honor to introduce our first speaker in this opening part of the webinar. And I would like to give the floor to Ms. Cisse Mariama Mohamed. She's the Director of the Department of Social Welfare, Vulnerable Groups, and Drug Control at the African Union Commission. Madam Director, the floor is yours.
Thank you, Moderator. Ms. Miwa, Kato, Director Division of Operation UNODC, Ambassador Adam Namm, Executive Secretary, Inter-American Drug Abuse Control Commission, eminent panelists, distinguished experts, excellencies, ladies and gentlemen. Greeting from the African Union Commission. We are headquarters in Addis Ababa, Ethiopia, and we are the Executive Secretariat of the African Union, which is an intergovernmental organization comprising of 55 member states. Our primary role is to formulate continental policies and frameworks and coordinate implementation by member states. At the onset, let me take this opportunity to thank UNODC and CICAD for jointly organizing this event. This webinar could not have come at more opportune time, coming as it does a few days after the African Union commemorated the African Union Day last week on Wednesday, September 9, 2020. As committed ourselves to the ideal and aspiration of the Africa we want, an integrated, prosperous, and peaceful Africa, we are cognizant of the challenges that compound the world drug problem, not least the COVID-19 pandemic that has had a significant impact on prison and detention facilities on the continent. On its part, the African Union continued to provide overall coordination, strategic guidance, training, and dissemination of good practices to assist member states in addressing the world drug problem. The African Union fifth strategic framework to guide drug policy development on the continent, the AU Plan of Action on Drug Control and Crime Prevention 2019-2023, encourage member states to implement alternatives to punishment for drug use, promote proportionality in sentencing for drug offenses, and provide services for people with drug use disorder in contact with the criminal justice system. Ladies and gentlemen, the African Union has thus been working with its member states to provide access to evidence-based treatment as an alternative to punishment with encouraging results. I'm happy to say many African countries have taken steps to reduce prison population, protect people in place of detention, to reduce vulnerability to the COVID-19. We look forward to sharing experience and good practices and learning from experience of our counterparts from Latin America and the Caribbean. We also look forward to continuation of this South-to-South cooperation and of course with the UNODC. I thank you for your attention.
Thank you, Madam Director, Ms. Mohamed. And please forgive me, I'm still getting to grip with this, switching with the technology. But thank you for your inspiring words. I would have a lot to tell about the great initiative of the African Union Commission, but there is no time. And instead, it is my great pleasure to introduce Ambassador Adam Namm. He's the Executive Secretary of the Inter-American Drug Abuse Control Commission of the Organization of the American States. Ambassador, the floor is yours.
Thank you, Giovanna, and good morning and good afternoon to everyone, depending on which side of the ocean you're on. Giovanna, yes, that is a mouthful. I'm sorry?
It wasn't
I serve as executive. I'm hearing a voice. I don't know if I'm being given an instruction.
No, I don't think you are.
Okay,
I think,
thank you.
You know, there was some interference, let's say. Please
I got it,
proceed.
okay. I serve, as Giovanna said, as Executive Secretary of the Inter-American Drug Abuse Control Commission, which is part of the Organization of American States, headquartered here in Washington, D.C. Many of you may know the commission by its Spanish language acronym CICAD. The CICAD Executive Secretariat is pleased to support UNODC in the organization of this webinar, together with the African Union. CICAD also collaborated with the African Union just yesterday in a webinar on drug demand reduction in Africa. I want to express a special thanks to Ms. Cisse Mariama Mohamed, Director, Department of Social Welfare, Vulnerable Groups and Drug Control, African Union Commission, and also Ms. Miwa Kato, Director, Division for Operations of UNODC. Pleasure to be with both of you. Alternatives to conviction or punishment, as UNODC refers to the concept, or alternatives to incarceration, which is the OAS term, have attracted significant interest worldwide for many years. OAS member states have long promoted these alternatives to traditional criminal justice to promote the human rights of their citizens and emphasize public health in drug policies. Today, we are in the midst, of course, of a pandemic that has altered our fundamental human social dynamics. As part of a global effort, OAS member states have responded to the pandemic with urgent public health measures aimed at stopping the transmission of the coronavirus. These emergency measures have made it much more difficult for those with a problematic substance use disorder to receive treatment and has limited the services that treatment professionals can provide. Similarly, COVID-19 has raised some difficult issues regarding incarcerated populations, given that prisons are often hotbeds of contagion. With the region's overcrowded and underfunded prisons, many countries are faced with challenging questions, such as, should inmates receive an early release? Can any of them be diverted into an alternative to incarceration program? And could any new defendants that are just now entering the criminal justice system be diverted into such programs? The answers require balancing public health and public safety in a constantly changing environment, which is precisely what this webinar is about. And this conference will undoubtedly provoke thoughtful discussion on this topic. Justice and health are inseparable issues when discussing alternatives to incarceration for drug-related offenses, especially during the pandemic. The drug trade involves millions of people in the Western Hemisphere, many of whom live in a condition of vulnerability. More than 3.5 million people are incarcerated in the Americas, 1/3 of who are incarcerated for drug-related offenses, often for drug use or micro-trafficking. The length of sentences for these offenses can be significant and can cause or worsen prison overcrowding. All of this translates into significant costs, both direct and indirect. For these reasons, there is great interest in alternatives to incarceration programs. More than half of OAS member states have either implemented or are exploring implementation of alternatives to incarceration programs to facilitate treatment, rehabilitation, and social integration, as well as to reduce the prison population, consistent with the OAS Hemispheric Drug Strategy and its corresponding plan of action. At the request of many OAS member states, CICAD has provided technical assistance to implement alternatives to incarceration. To date, that assistance has included extensive monitoring and evaluation, case care management to facilitate the social and economic integration of drug-related offenders, process evaluations of problem-solving courts, and an analysis on the ways in which women, men, and LGBTI communities interact with the criminal justice system. Moreover, as a response to the pandemic, CICAD has organized, or in this case, co-organized, a series of webinars such as this one. These virtual events have provided fora for OAS member states to share their best practices and lessons learned, and to demonstrate the capacity of the region to innovate and confront this shared challenge. Salient conclusions from previous events have included the need for clear and constant communication between health experts and criminal justice stakeholders, the creation and updating of biosecurity protocols, both for criminal justice involved individuals and criminal justice officials, the creative use of technology to support treatment and social integration services, such as virtual hearings and therapy, a recognition that diversion and probation reentry programs can alleviate prison overcrowding, and an understanding that the creation of case care management systems can enhance the effectiveness of alternatives to incarceration programs. Today's webinar elevates these discussions from the Western Hemisphere to an interregional level. We are fortunate to have with us today distinguished global experts. It's my hope that you will find today's discussion useful, not only on a theoretical level, but also for the very practical work of operating alternatives to incarceration programs. Thank you very much.
Gio, you're muted.
I know, I have to stop muting myself because I am cognizant of various noises around. And so this ruined my heartfelt thanks to Ambassador Namm for introducing the initiative of CICAD in the field of alternatives and help us opening this webinar. We have always looked at the initiative of CICAD in all fields, but in particular in this one where they have really opened the path a long time ago for inspiration and knowledge. So thank you again. And now I have the pleasure to introduce our own director, Ms. Miwa Kato. She is the Director of Division for Operations here at the United Nations Office on Drugs and Crime. Miwa, since she's my director, I'll allow myself, the floor is yours.
Thank you very much, Giovanna. Good morning, good afternoon to various colleagues around the world. Madam Director Cisse Mariama Mohamed, the Director of Department of Social Welfare, Vulnerable Groups and Drug Control of the African Union Commission. Ambassador Adam Namm, Executive Secretary of the CICAD OAS. Very good morning to you and to all the distinguished colleagues and guests around the world. I can see there's 174 participants, and I think some of us are around one screen more than one. So I think we can all agree that this, among all the challenges that this year of 2020 has brought to us, I think one good thing that we're finding is that we're better connected virtually. And this is providing opportunities for more open exchange across the world. So thank you very much to the colleagues who have thought of organizing this to adapt that very quickly on issues of priorities for all of us. And for me, it's an added pleasure to be able to join this session, which is an interregional event. As we look at the global operations of UNODC around the world, we sometimes struggle even to have regional discussions, right? But it's very important that we look at best practices, looking at challenges and common solutions together across regions. We, frankly, as UNODC, learn a lot. We're hearing a lot about Africa, a lot about Latin America, unfortunately, in relation to COVID. So it means a lot for us to be able to learn from and also help bridge together amongst us various realities that's facing our common humanity and see how we can gear our own small contribution to the discussions. So thank you very much for this opportunity. It's very much my pleasure to be a part of this joint webinar on treatment and care of people who with drug use disorder in contact with the criminal justice system. Alternatives to conviction or punishment, impact of COVID-19 in Africa and the Americas. Let me begin by welcoming you and conveying a special appreciation to CICAD, Organization of American States, and the African Union for co-hosting this very important event. I would also like to express our deep gratitude for distinguished speakers from so many countries, including Costa Rica, Kenya, South Africa, and Trinidad and Tobago. This is a special occasion for us to bring together regional debates and frontline experts from Africa and America to share knowledge, challenges, and best practices in criminal justice settings in the midst of the COVID-19 pandemic. Globally, prison overcrowding and poor health and sanitation conditions have been contributing to a rapid spread of COVID-19 in corrections, prison systems, thereby threatening the health of not only the prisoners and prison staff, but also the wider communities that interact with them. In May this year, UNODC had the pleasure to partner with the global health, human rights, and development experts to release a joint statement on COVID-19 in prisons and other closed settings. This was to draw attention to the heightened vulnerability of people in prison and other closed settings to the COVID-19 pandemic, and to urge political leaders to take all appropriate public health measures in respect of this particular vulnerable population. The joint statement suggested reducing overcrowding, ensuring health, safety, and human dignity, as well as access to continued health care services in line with the UN rules and guidance on prisons. The risk of COVID-19 stands in a continuum with other serious difficulties, however. The global prison population has been steadily increasing, and that has been a major obstacle to achieving safe, secure, healthy, and humane prison environments, undermining some of the objectives of imprisonment, which relates to the rehabilitation of offenders while safeguarding health and safety. This was already the case before COVID, and the situation has gotten so much worse. Nevertheless, the post-COVID-19 environment is presenting an opportunity to improve and innovate how criminal justice systems operate and to address chronic shortcomings. In an effort to build back better, member states must seize the opportunity to scrutinize and redefine their use of incarceration through increasing the use of alternatives to imprisonment of appropriate cases with drug use and improving the efficiency of criminal justice processes. So many prisoners are there behind bars in pre-trial detention conditions. So many people behind bars are there for administrative repetition of administrative charges rather than criminal ones. And this has been always a point that UN has been pointing out, that we need a better policy on this. But this current situation with COVID, which is highlighting an increased risk to this particular prison population and their wider community, is making this debate even more urgent and relevant. In this context, the community-based alternatives would need to be considered as effective places of referral in condition a coordination between the criminal justice system and other sectors, especially the social affairs and health services. With general support from the United States State Department, INL, UNODC, in collaboration with the WHO and regional partners such as AU, CICAD OAS, and EMCDDA, developed a a handbook on treatment and care for people with drug use disorders in contact with the criminal justice system. Building upon its long-standing expertise in evidence-based and gender-sensitive reforms towards fairer, more effective, and humane criminal justice systems, UNODC is very ready to work with member states in enhancing the sustainable use of non-custodial measures and improving the efficiency of their criminal justice system. This can be achieved only through close collaboration with member states, regional partners such as the AU and CICAD OAS, with a view to reducing prison overcrowding, improving health and public safety, and rethinking sometimes excessive and disproportionate resort to imprisonment. As Ambassador Namm has pointed out earlier, the need to balance public health and public security concerns in a changing context of the world. We really, I think, need to question some of the assumptions we have, some of the practices we take, and to make this issue beyond the topic that is of interest to people who are interested in improving prisons and health. I think it is a much wider social question that needs to be asked. There's a lot of politics around it, but I think it is time for us to take courage to look at what a responsible recommendation would be, and where is it better place to start discussing these issues than to start in forums such as this, where we have so many practitioners from around the world facing this issue from day to day, looking at new opportunities for more realistic, more enlightened way of dealing with this question of criminality. If we can come to some concrete recommendations we can take to our member states to offer solutions, that would be a wonderful contribution I think we jointly make. So thank you once again for this opportunity. I look forward to hearing all the different insights and count on our colleagues to carry on this work so that this leads to concrete action and changes. Thank you once again, and all the best for the remainder of the proceedings. Thank you.
Thank you, Miwa. And thanks again to all our leaders, Director Mohamed, Ambassador Namm, Director Kato, for being with us to open the webinar. So I think that with this, we can consider concluded the opening part, the opening session of the webinar, and we can start really thinking to inaugurate the segment on treatment for people with drug use disorder in contact with the criminal justice system, specifically on alternatives to conviction and punishment. And in this context, it is my great pleasure to introduce two colleagues of mine. Ms. Anya Busse, she's program officer here at the Prevention, Treatment and Rehabilitation section of the UNODC, and she will jointly present with Ms. G.A. Lee. She instead is Crime Prevention and Criminal Justice Officer with the Justice section at UNODC. As you can see, in this kind of initiative, we work very much together, and they will take turns in introducing the topic for us, but I think Anya might be starting, and the floor is yours.
Thank you very much. It's an honor and also a pleasure for Jamie and me to be with all of you today and to speak about treatment for people with drug use disorders in contact with the criminal justice system as an alternative to conviction or punishment, and that especially in these challenging times of the global pandemic that you all have mentioned already. To implement treatment of drug use disorders as an alternative, like many of you said, it's important to understand the overall availability and accessibility of treatment services, including in the community. And at global level, access is very limited. And we can see that only 1 out of 8 of the 35 million people in urgent need of drug use disorder treatment have access to it. And there are even more people who have used drugs in the past year. This situation with regard to access to treatment is worse in some regions and also for women. We have seen that drug markets and drug use patterns have reacted to the global COVID-19 pandemic based on emerging and not yet conclusive information though. There seems to be a trend towards more available substances such as alcohol, but also a dangerous trend to more harmful modes of drug consumption. The intensification of controls related in reality with COVID-19 prevention measures have been associated with an increase in drug-related arrests in some countries. We will also hear more about the flexibility applied to the provision of alternative measures during the pandemic from Jamie. People who use drugs often have a history of incarceration, and drug use is even more prevalent in prison settings than in the community. Prison, as again many of you have mentioned, is a high-risk environment for COVID-19 transmission, including due to prevailing prison overcrowding, and has also been previously and prior to the pandemic been associated with an increased prevalence of mental health disorders, tuberculosis, or HIV, to just name a few. Globally, over 2 million people are estimated to be in prison for drug-related offenses, and that would then be roughly 20% of all inmates. Among those, 83% are believed to be serving sentences for possession of drugs for personal use. Please note, though, that these are not official UNODC estimates. Healthcare in the community and evidence-based treatments, such as outlined in the UNODC WHO International Standards for Treatment of Drug Use Disorders that you can see here, is the most effective response to drug dependence per se. There are then special considerations for people with drug use disorders in contact with the criminal justice system, as outlined in the already mentioned UNODC WHO publication on the topic, which you can also see here. The impact of COVID-19 on alternative measures and the provision of drug treatment during the pandemic, we will discuss much more today. And as mentioned in the opening remarks by my director, Ms. Miwa Kato, UNODC, together with other UN agencies, has called for increased efforts to resort to non-custodial measures in the light of the pandemic, especially for eligible people with pre-existing health conditions, which could of course include drug dependence, while at the same time also closing compulsory detention facilities for people suspected of using drugs or living with drug use disorders. And this will of course require a joint effort and additional investment in increasing access to community-based treatment to close the earlier mentioned treatment gap. And with that, over to Jamie.
Thank you, Anya. It's also a great pleasure to present on behalf of the Justice section of UNODC on the issue of alternatives to conviction or punishment. As you can see on the screen, the international obligations and commitments of member states in this area are contained in several binding instruments and normative standards that have been unanimously adopted over the years. And collectively, they provide that imprisonment should not be the default option for criminal offending, and that for appropriate cases, alternatives should be used wherever possible. And for those with drug use disorders who are in contact with the criminal justice system, the 1988 Convention encourages member states to provide treatment and aftercare as an alternative to conviction or punishment. Next. And over the years, UNODC has been mandated by several policymaking bodies of the UN to assist member states in implementing alternatives to imprisonment. And some examples of such mandates are on the screen. And as you can see, our assistance ranges from review of legislation, assessments of the current situation and recommendations, capacity building and training workshops, as well as awareness raising activities. Next. Here are some of our selected technical assistance activities in this area, with a focus on those provided in Latin America and Africa in the recent years. And in all of our technical assistance activities in this area, our main point that we emphasize is that the importance of establishing or improving sustained and structured coordination and cooperation between the justice and health sectors, so that the treatment as an alternative to conviction or punishment can be delivered effectively as a joint effort. Next. And since March, UNODC has been mapping and analyzing the emergency measures that member states have taken in response to the COVID pandemic. And I'd like to share some of our preliminary findings from this exercise. First, in over 80% of the countries for which we had information, the emergency release mechanisms were limited to convicted prisoners, as opposed to both pretrial detainees and convicted prisoners. This can be a problem, as in many countries, as you know, there is a large number of people behind bars awaiting trial, sometimes even more than convicted prisoners. And in many countries, those are the people who suffer from the most harsh conditions of being behind bars. So this is something that should be addressed going forward. And second, the most common mechanism of release was through presidential or royal pardons. And this is presumably because they were already constitutionally available in law and thus could be quickly implemented without much bureaucracy. And this also meant that it contributed to the why only convicted prisoners were released. Some countries also had amnesty or reassessment of bail amounts for pretrial detainees, but at a much, much lower rate. And third, the release mechanisms were usually reserved for prisoners with less serious offenses with short sentences, and those close to the end of their sentences, and vulnerable prisoners, such as the elderly, children, and those with existing health conditions. Many explicitly excluded offenders of violent crimes, such as sex crimes, domestic violence, as well as security or terrorism-related offenses. And fourth, it's interesting to note that in some countries, drug-related crimes were specifically excluded from being considered for emergency release, regardless of the gravity of the offense. Next. A good practice example that we observed during our research comes from Nigeria. And in Nigeria, the judiciary took the leading role in reducing the prison population by implementing an expedited review of cases. Back in May, the Chief Justice of Nigeria adopted a broad and general criteria to consider by judges of the country and required that each state report back on implementation. And the judges of each state increased their review of the cases of pretrial detainees and post-conviction imprisonment. And then as a result, by July, the prison population of Nigeria went down by close to 17%, which is very impressive. And this was a relatively simple yet flexible approach that in the end was very successful in reducing the prison population for both pretrial and convicted persons. And we believe that this can serve as an inspiration for other countries that are in need of reducing the prison population worldwide. And now Anya will share more information about the health side of this problem. Thank you for your attention. Anya, you're muted.
Now, sorry, I was not allowed to unmute myself. We also wanted to share with you an example on the health side, which happened during COVID-19. And so we could see, for example, in Nigeria and in Ecuador, 2 countries that UNODC worked with, good practices in terms of maintaining access to treatment in the community open. So in Nigeria, for example, UNODC, together with Nigeria and a group of people previously trained, launched what is called Drug Help Net, which is providing over-the-phone assistance to people who use drugs and their families. And in Ecuador, based or following an earlier webinar, which we have organized, UNODC had the honor to provide technical assistance to the government and provide guidance and help develop a protocol on maintaining residential drug use disorder treatment services open in the country. I would also like to draw your attention to what you can see there in the picture, the suggestions about treatment and care and rehabilitation of people with drug use disorders in the context of COVID-19, which UNODC has released earlier this year and which has been translated into 16 languages by now, and which is really a tool to help treatment continued even in times of the pandemic. So with that, let me see if I can, no, I cannot move slides anymore. Yes, and with that, we're closing. We thank you very, very much. On these 2 websites, you can find more publications, both from the UNODC Justice section and the UNODC Prevention, Treatment, Rehabilitation section, including on this topic of treatment as an alternative to conviction or punishment. So with that, thank you very much, and looking forward to hear from all the other speakers.
Thank you, Anya, and thank you, Jamie. We now have what is for us a very a dear friend and colleague, and Dr. Jane Marie Ongolo. She will present on policies and COVID-19 regional experiences in Africa. But first, let me introduce her. She's the head of social welfare, vulnerable groups, and drug control and crime prevention at the African Union Commission. And Jane Marie, Dr. Ongolo, the floor is yours. We see you.
Yeah, thank you very much, Giovanna, and it's my pleasure to present on behalf of the African Union Commission. I'm trying to get my slide on the screen.
They are here.
It's here now, yeah, okay. So I'll briefly be talking about treatment as an alternative to imprisonment, looking at policies and experiences during the COVID-19 situation. My director has eloquently introduced the African Union Commission, so I'll skip that slide. Like the rest of the world, Africa has been struggling with huge prison populations, and the majority of those in prison really are due to minor offenses related to drug use. So alternatives to incarceration gained traction since 2013, when the African Union adopted the AU Plan of Action on Drug Control and Crime Prevention in 2013. This policy document spotlighted the health and other social consequences of drug use and approaches that could be used. And in particular, it talks about institutionalization of diversion programs for drug users in conflict with the law, especially alternatives to incarceration for minor offenses. And with this and many other policy pronouncements, there's been growing understanding that prison is not the right place to treat drug use. Just to highlight again some of the factors that have been mentioned by previous presenters, prisons are characterized by congestion, and it holds a big share of petty offenders, including minor drug-related offenses. And as we've seen, Prisons are high-risk environment for transmission of infectious diseases such as HIV, hepatitis C, and now recently the challenge that we're dealing with, COVID-19. But COVID-19 containment measures are premised on social distancing and keeping at most hygienic conditions, which are really difficult to maintain in the prisons. So for this reason, though not intended, COVID-19 is beginning, at least from the experience we are seeing in the continent, to accelerate application of alternatives to incarceration for minor offenses in general, but as well as to divert drug users from the criminal justice system. Just quickly, some measures that the African Union Commission has put in place to contain COVID-19, working with its member states. We have an African task force for coronavirus at the heads of states level. We have a COVID-19 response fund. We also launched what we call Partnership to Accelerate COVID-19 Testing. There's been massive deployment of volunteers to countries that have been worst affected, but significantly, the African Union has provided several guidelines to member states on different containment measures, including those that relate to prison settings. But an important one which I want to highlight is the development of comprehensive socio-economic response to the health pandemic, looking at issues beyond health, beyond public health, but also other risk factors that affect vulnerable populations. I don't know what's happening to this slide. There's strong political commitment in Africa, obviously, to address there's strong political commitment to address alternatives to incarceration in Africa, but the strongest voice, I said that it's received traction with the adoption of the AU Plan of Action on Drug Control and Crime Prevention in 2013, but the strongest voice has been seen in the recent Plan of Action covering 2020 to 2023. I don't know what's happening to my slides. They're kind of misbehaving. So we are all learning to work in this platform, Giovanna. So in this
it looks good now.
Yeah, in this latest policy document, the AU Plan of Action on Drug Control and Crime Prevention 20 to 23, it's premised on human rights approaches, and two of its pillars address alternatives to incarceration. We have pillar one, which kind of has disappeared from my screen. Pillar one talks about drug demand reduction measures. And in those drug demand reduction measures, it includes treatment in the prison settings. The second pillar that addresses this topic is on pillar 5, on cross-cutting issues focused on drugs and human rights pertaining to all vulnerable groups, especially youth, women, children, and communities. In its objective 4, the plan requests member states to adjust approach towards people who use drugs from punitive to more supportive measures. The other policy instrument focusing attention on this topic is the Common African Position for UNGAS, which was developed in 2016, where member states committed to support the collaboration of public health and justice authorities in pursuing alternative measures to conviction or punishment for appropriate drug-related offenses of minor or non-violent nature, in accordance with the international drug conventions, but of course also prevailing national legislation. This is important because it just happened. During the third ordinary session of the African Union Specialized Technical Committee on Health, Population and Drug Control in August 2019, this is a ministerial meeting of government agencies responsible for drug control. Member states committed, this is really very important, member states committed to invest in a balanced and integrated approach to drug control at the policy, strategic and implementation level, ensuring that people who use drugs are not punished, but are provided with access to treatment and psychosocial services. But also recognizing that imprisonment for drug users does not reform them, but rather perpetuates criminal activities, and therefore to consider reforming the penal code and legislation. Having said that, therefore, how does this translate at the national level? Most country legal systems have discretionary practice when making sentencing determinations. Judges consider the gravity of the offense, the circumstances of the offender, and public interest. And this has translated to wide application, oftentimes benefiting drug users in conflict with the law, even where express law for alternatives to incarceration does not exist. But we have a few countries who specifically have laws addressing drug use in prisons and alternative measures, and that's Algeria, Mauritius, Togo, and Tunisia. But in practice, many countries actually implement alternatives to incarceration through probation and community aftercare services in collaboration with NGOs and community outreach workers. Again, quickly, some countries that use probation, aftercare, and community service orders are those on the screen: Algeria, Kenya, Mauritius, Nigeria, South Africa, Tanzania, Togo, Tunisia, and Uganda. And in terms of drug treatment court orders, we have Mauritius that also offers treatment in prison. Some measures include caution and being released to family counseling services through drug commissions, especially in Zambia. Special initiatives such as early release of prisoners who would have been eligible for community service, but for whom sentence was forever, for whatever reason, not considered. I would like to quickly show a case study from Zambia, their experiences and some of the measures that they've taken during COVID-19. Of course, many countries are already doing things. We'll be having South Africa and Kenya presenting. We've heard about measures being undertaken in Nigeria. So Zambia is just one example, not necessarily indicating that the only ones who are doing well. Zambia introduced guidelines to implement alternatives to incarceration for people with substance use disorders through guidelines for prevention of C19, including decongestion of prisons and police holding cells. So in particular, they have a pilot diversion program being implemented by Ministry of Community Development and Social Services. So for this reason, therefore, their law enforcement agencies have enhanced implementation of alternative measures in the time of COVID-19, using, for example, police bonds, warnings, referrals from courts to counseling and rehab services for drug users with minor offenses, but also young offenders who, for whatever reason, find themselves in conflict with the law. This, therefore, has enabled several people with drug use disorders to receive treatment and care in hospitals and counseling centers. Due to those measures, we see that 183 people have been diverted from the prisons and received treatment outside through different services. And across the continent, we see that between January and May, many countries purposed to release a number of prisoners through either pardons, early release and pardons, pretrial detainees and temporary releases, etc. And we can see that the numbers are really quite high, just from Algeria, 5,000, Kenya, 4,000, Morocco, 5,000, Nigeria up to 50,000. And that's not really surprising considering also the presentation that was made by Anya earlier on through pre-trial detainees. So we can see that in spite of the existing challenges, COVID-19 has really accelerated the implementation of alternative to incarceration measures in Africa. But challenges remain, which we should take note of: legislative and policy barriers, limited treatment options, as we notice that some diversion programs don't have viable treatment, and chances that people who are referred to those facilities continue using drugs and they get rearrested, bringing to doubt the effectiveness of diversion measures. And again, as Anya said, that only 1 out of 8 people are really able to access treatment facilities. There's also weak continuum of care mechanisms linking socioeconomic integration between the law enforcement, the treatment, and social integration. But these measures also suffer from problem of perceptions, where people think that alternative sentences are soft, and they're wanting people who've gone through the courts to be imprisoned so that justice is seen to be done. In the absence of alternative viable sentencing options, courts find themselves between a rock and a hard place, whether to imprison or to release back to the community. I am finishing quickly already. So what we've seen, there are lots of opportunities. So I'll turn these opportunities into recommendations. We've seen gains through COVID-19. If we can optimize on these gains made during COVID-19 and really increase the mechanisms of diversion from the prison settings. There's also need to enhance existing collaboration and goodwill between courts and social services. Need to update legislation policy to support emerging practice from the ground, and to document, evaluate, and upscale existing good practices. In closing, just to acknowledge the good work that's being done by our member states. As a secretariat, we only coordinate and provide policy guidance, but the response by joining this conference already is a testament to your commitment to this, and I applaud you. We will continue working together to support by providing good practices and leveraging technical assistance as is necessary. I see that we have more than 30 member states represented in this webinar, and that's the way to go. So thank you very much, Giovanna. This was just a quick highlight on our experiences during COVID-19. Thank you, and over to you.
Thank you so much, Jane Marie, and for sharing some really, really exciting experiences in the African continent, but also some really great news in terms of advances in the normative, right? The decision that you shared that was taken in August is really brings the field forward a lot, and it's great to be here together to think together how to make it a reality. And from Africa, let us now move to the Americas. I have another friend and colleague to introduce to you, and please join me in welcoming Mr. Antonio Lomba, the Chief of the Institutional Strengthening Unit at the CICAD of the Organization of the American States. And he will tell us about policies and COVID-19 regional experiences in the Americas. Mr. Lomba, Antonio, the floor is yours.
Giovanna, thank you so much. What a pleasure being here with you all. I'm going to turn into Spanish to give some flavor to this.
Thank you.
And integrate other languages. So you have Spanish interpretation down there, all of you. Un placer realmente estar con ustedes. Da gusto ver tantos nombres y rostros, algunos, e instituciones tan conocidas y tan amigas de la CICAD. Gracias por la participación. Veo que el número de participantes va subiendo, ya estamos por los 200. Bienvenidos a todas y a todos. Quisiera aprovechar para dar algunos detalles más sobre algunos de los programas que mencionaba el embajador Namm en sus palabras de bienvenida y acusar un poco, de alguna manera, reconocer que muchos de los temas que ya se han mencionado ahora sobre el impacto concreto, sobre algunas alternativas al encarcelamiento, son temas que no son nuevos tampoco, se repiten aquí en este lado del hemisferio, y entraré en algún detalle en alguno de ellos, pero bueno, agradecer también a los dos participantes que hay de la región que hablarán más adelante de algunas experiencias concretas desde la unidad de fortalecimiento institucional de la CICAD. Nosotros, como saben, damos asistencia técnica y apoyo a los Estados miembros en todas las áreas descritas en la Estrategia Hemisférica sobre Drogas y el Plan de Acción, que incluyen, entre otras, el tema de las alternativas al encarcelamiento. Bueno, como saben, en el 2015 la CICAD desarrolló un manual bajo el liderazgo del Gobierno de Colombia, un informe sobre alternativas al encarcelamiento que incluía más de 60 alternativas. Hace un par de años pudimos revisar, como mencionó también la directora Kato hace un momento, de Naciones Unidas, en sus palabras introductorias, algunas de esas alternativas en un esfuerzo que lideró Naciones Unidas y la Organización Mundial de la Salud. Muchas de esas alternativas se han ido implementando a este lado del Atlántico, otras no, pero en cualquier caso son siempre referencias para la reflexión y para la cooperación horizontal y para impulsar nuevas medidas ante situaciones diversas, ¿no? Sobre todo con las que nos encontramos, por ejemplo, ahora con el tema de la pandemia. De hecho, todos los programas que voy a mencionar ahora se ven afectados directa o indirectamente por la pandemia. Han tenido que, de hecho, en estos meses hemos sido testigos de grandes adaptaciones, conversiones de cosas que estaban previstas de hacerlas de una manera y que han tenido que adaptarse a un entorno diferente. El acceso a los tribunales ha sido limitado. Bueno, los casos han tenido que pasarse a otros momentos también. O sea, ha habido, como en el tema de salud, ha habido muchísimos ajustes también en el área de justicia y que han afectado, y de alguna manera no podremos ver el impacto real de lo que esto está suponiendo hasta que pasen unos meses, ¿no? Y nos sentemos un poco a reflexionar sobre este impacto. De todos modos, sí que en este sentido quería mencionar estos programas para que los conociesen. Algunos de ustedes participan, los países que están participando también en este webinar son actores líderes de estas iniciativas que se están llevando a cabo en este lado del hemisferio. Gracias al liderazgo de los Estados miembros participantes hemos podido, de hecho, apoyar exploración y implementación de diferentes alternativas al encarcelamiento, muchas de ellas centradas en la fase penal actualmente, pero cada vez más en las fases preprocesales. Buscando alternativas que actúen de forma preventiva, tanto con la población adulta como también adolescente. Entre estas alternativas, resaltar algunas se han mencionado ya antes, pero aquellas que bajo el paraguas de justicia terapéutica en general se están poniendo en marcha, o más concretamente los programas de justicia restaurativa, como escucharán más adelante, o de tribunales de tratamiento de drogas, o programas de derivación o disuasión en fases prejudiciales, o las cortes o tribunales comunitarios, o aquellas de reentrada en las fases penitenciaria y pospenitenciaria, con todas las implicaciones que tiene y que la doctora Marie acaba de mencionar también en la experiencia de African Union con el tema penitenciario. Estos y muchos otros programas están siendo, de hecho, implementando de manera creciente en los Estados miembros de la OEA. En un esfuerzo con otros organismos como Naciones Unidas, totalmente activo, o como el Colombo Plan, y con el apoyo de diversas instituciones, expertos, y con financiación del Gobierno de Estados Unidos, podemos apoyar procesos de capacitación y sensibilización sobre distintos mecanismos que permiten la implementación de alternativas al encarcelamiento. Son muchos los expertos de diferentes organismos internacionales que están participando en este esfuerzo creando una especie, un currículum formativo que permita que personas que tienen capacidad de toma de decisiones en la región, pero también operadores del sistema de justicia penal o de los ámbitos de la salud o de servicios sociales puedan, de una manera estructurada, digo otra vez, ver el compendio de alternativas posible al tiempo de observar buenas prácticas al respecto. Creo que se ha avanzado mucho en la cooperación horizontal y ahí agradezco realmente el liderazgo de Naciones Unidas bueno, ya espero que en el futuro también, doctora Marie, que podamos trabajar también con African Union en alguna de estas experiencias horizontales y otras instituciones, como mencionaba antes, como el Colombo Plan. En 2019...
Antonio, una disculpa por interrumpirte.
Sí,
¿Sería
sí.
posible que acercaras tu micrófono un poco más? Porque
Por
nos
supuesto.
están comentando los participantes que hay problema de audio. Gracias.
Muchas gracias. ¿Mejor ahora?
Se oye perfecto. Así
Qué bien. Bueno, me pego el micro. Gracias, Pamela. En 2019, gracias al apoyo del Gobierno de Canadá, pudimos llevar a cabo una serie de estudios, diagnósticos y evaluaciones en varios países de la región sobre el estatus y proceso de implementación de varias alternativas al encarcelamiento. Uno de los hallazgos más significativos fue la debilidad institucional para garantizar procesos de integración social de las personas en conflicto con la ley, personas con uso problemático de sustancias, y en muchos casos estos procesos de integración social sucedían sobre la base de voluntarismo de los operadores, pero no como una respuesta institucional que vinculase a los distintos actores participantes. En ese sentido, en este 2019 iniciamos y estamos ahora en el 2020 en un proceso de apoyo, gracias a la financiación también del Gobierno de Estados Unidos, para estructurar la capacitación de lo que llamamos sistemas de gestión y atención del caso, o CCM, le llamamos más coloquialmente en inglés, que ha empezado a dar sus frutos en países ya del Caribe. Hemos tenido varias experiencias de capacitación en Jamaica y Trinidad y Tobago, y en este último se ha podido incluso iniciar la creación de un sistema piloto, estas negociaciones ahora de este SSM, que fortalece las estructuras existentes y el papel de los oficiales de libertad condicional, los probation officers, etcétera. No es el momento más fácil, bajo una pandemia, de poner en marcha estos pilotos, pero se está pasando, está sucediendo incluso a distancia. Esperemos que esta oferta de capacitación a través de un currículum formativo ad hoc permita que otros países puedan incorporar sistemas de seguimiento del caso para cerrar exitosamente los ciclos de integración sociolaboral. En ese sentido, hay una transversalidad clara entre muchos programas, gracias a la cooperación española y programas como Zambia, por ejemplo, que dedica esfuerzos al tema de la gestión local y las políticas locales, o recientemente también la cooperación italiana a través del programa Fortalí. Se ha podido incluso avanzar en el apoyo de fortalecimiento de políticas y estrategias locales para que todas estas alternativas también, entre otras muchas cosas, también pueda llevarse a cabo a través de procesos de integración social estructurados también en las propias comunidades y con actores locales, incluyendo colaboración con servicios de salud, pero también con las comunidades terapéuticas. El apoyo a la implementación de alternativas al encarcelamiento en la región es importante, pero también, y cada vez más si cabe, es el apoyo a procesos de monitoreo y evaluación. Creo que hacer énfasis en este tema porque, de hecho, este año 2020 y a lo largo de 2021, y gracias al apoyo de la cooperación canadiense podremos llevar a cabo un impulso a lo que es el sistema de monitoreo y evaluación, a generar capacidad o generar que se instale la capacidad que permita que se puedan medir modelos como en los tribunales de tratamiento de drogas u otros y medir cuantitativamente y cualitativamente el impacto de los mismos, ¿no? Cada vez más se están explorando no solo modelos alternativos al encarcelamiento para adultos, sino también para población adolescentes. En esta región, en los últimos años, Jamaica o Colombia o Perú han podido profundizar en modelos concretos para población adolescente. Solo recordar que, según muchos estudios, el 80% de las personas que están en prisión como adultos ya lo estuvieron en contacto con el sistema de justicia penal o policial cuando eran adolescentes, y de alguna manera, si no ponemos mecanismos que actúen de manera preventiva en la población adolescente o intervenir cuando inician estas conductas delictivas, no podremos revertir la puerta giratoria en la comisión del delito actual. Por último, quiero cerrar mencionando un programa, una iniciativa que se está llevando a cabo con el liderazgo de 5 países: Argentina, Colombia, Costa Rica, Jamaica, República Dominicana. Gracias también al apoyo del Gobierno de Canadá, se está llevando a cabo el programa de género en el sistema de justicia penal para explorar alternativas al encarcelamiento basadas en la evidencia para delitos relacionados con las drogas. Es un proyecto, una iniciativa, muy brevemente, que pretende identificar mecanismos procesales y extraprocesales alternativos al encarcelamiento y dar diversas opciones, ver las opciones que se están dando a mujeres, a hombres, a miembros de la comunidad LGTBI, al enfrentar el sistema de justicia penal por este tipo de delitos. Como parte de esta iniciativa, de hecho, estamos trabajando con estos 5 países en determinar qué número de personas están entrando al sistema de justicia penal con algunos pilotos, algunos tribunales, y ver la desagregación por género en el sistema. Solamente quería mencionar estas experiencias, todas ellas, una detrás de otras, se están viendo afectadas por el tema del COVID, en temas que ya han mencionado otros ponentes y que yo creo que van a entrar más en detalle en la práctica ahora los siguientes expositores, pero gracias por el espacio de poder compartir estas experiencias, gracias a Naciones Unidas y African Union por el hermanamiento generado a través de este webinar. Un placer estar con ustedes y gracias al equipo que hay detrás de los telones para organizar este tipo de eventos.
Thank you so much, Antonio, not only for the flavor, but for the amazing content and all of the examples and the rich experience coming from your organization and, of course, the member states of the Americas. And as we have now, toured all of the globe and the international organization that have joined hands in this effort, I think we turn now to the real concrete of this webinar and to really hear from some country level experience. And the first one that I would like to welcome is Kenya. We are honored to have Miss Florence Macharia. She's Senior Principal Magistrate, Head of Station at Shanzu Law Courts. And she will share with us a country-level experience from Kenya. Ms. Macharia, the floor is yours. Thank you.
Good morning, good afternoon, and good evening.
Hello.
My name is Florence Macharia. I'm from Shanzu Law Courts, and I'm here to give you the experience from the Kenyan perspective. And just to give you a background, Kenyan legal system is based on its statutory law, common law, customary law, and in Islamic law. The criminal justice system has evolved from the common law tradition to modern day system due to the efforts by the government to reform the sector. The reforms have been experienced in the judiciary, which is the major stakeholder. For example, we have the decongestion program in the prisons, which includes building of courts inside the prison, and Shanzu Law Courts, which is inside Shimolatewa Maximum Prison, Mombasa, and Kahawa Law Courts, which is in Kamiti Maximum Prison, Nairobi. And these courts have come into existence courtesy of the partnership and the support of the UNODC, and they mainly handle counter-terrorism and anti-narcotic drug cases. The Kenyan Constitution, which was promulgated in 2010, is transformational and brought about the much needed reforms in the criminal justice sector. Among the key articles relating to the criminal justice sector are found in the Bill of Rights, and relating to the accused persons, they include presumption of innocence, right to fair hearing, right to bail and bond, access to justice, information to reason for arrest, and so forth. And it's important to know that the Kenyan legal system is adversarial. And just to take you through briefly about the criminal justice process, we start with the arrest, which is either with or without warrant. Then the police bonds are granted during investigations. Then the accused person or the suspect is presented to court for plea. Thereafter, if the accused person pleads not guilty, we grant the bond, which is a constitutional right, unless there are compelling reasons as to why the bond should be denied. And then we have the pre-trial proceedings. We proceed to full trial, where we hear the prosecution's case. And if the accused person is placed on his or her defense, we hear the defense case. Thereafter, judgment is entered. and then we proceed on to sentencing. We apply alternative to formal criminal justice process, and which is one, the alternative justice system, which is encouraged by the Constitution. And there's already a policy in place, and we've had the UNODC also partner with us when we are coming up with the AJS policy document. And these assist the judges, the magistrates, and the stakeholders in the criminal justice system to apply alternative forms of criminal justice as opposed to the formal justice system. And part of the process we encourage the drug users to be put through the alternative justice system as opposed to the formal justice system. And then we also have the plea agreement. This is where the offender is charged in court, and there's a mutual agreement between the prosecution and the offender or the representative to bring a case to an end. And the written plea agreement is filed in court at any time of the trial, but before judgment is entered. Another form of alternative to the formal system is diversion. This is where the prosecution waives the prosecution or discontinues proceedings either with or without conditions. Then we have the decision to charge or not charge, which is done by the prosecution, and this saves the court's time and the public resources. And now fast forward, when we go to sentencing, in Kenya, we have a sentencing policy guidelines that guides the judicial officers when it comes to sentencing. And we observe the following objectives. Retribution, this is where we punish the offender in a just manner. There's deterrence, this is where we deter the offender and discourage the potential offenders. There's rehabilitation, where the offender is reformed. We have restorative justice, the offender contributes towards the victim needs. We have community protection, where it focuses on incapacitating the offender. And then we have denunciation, that is the condemnation of the criminal conduct by the community. And it's important to note that any form of sentence that is applied, we do it geared towards meeting the above objectives in totality. And then we have now dealing with the drug issue, which is very common in the coastal region. And this is where the Shimo La Tewa and the Shanzu Court is located. We have the Shimo La Tewa Shanzu Medically Assisted Therapy Clinic, and it's locally known by the community as the Methadone Clinic. It's located within the Shimo La Tewa maximum prison, and it started its operations in April 2020. And it's the first of its kind in the Kenyan prison. The target group was the heroin injecting users living in prison. And it's also important to note that this is a UNODC project in partnership with the Kenya Prison Service and the county government of Mombasa. Previously, before the clinic came into operation, the prisoners who are needing the therapy would be taken to Kisauni area, and these posed challenges such as expenses incurred to transport the patients, the security risks involved, loss of manpower as the officers escorting the prisoners would be engaged in more useful duties other than escorting the prisoners to a clinic outside the prison area. The clinic has also opened doors to members of public who are referred to the institution by the partnering NGOs. And what happens at the clinic, the prisoners who are under the methadone program are treated on daily basis from 7 a.m. to 9 a.m. East African time. And the doors are thereafter open to the members of public from 9 a.m. to 4 p.m. East African time. And there's a clinical officer in charge of the clinic who has been seconded by the Mombasa County government. And then the prison service has provided the farm tech and the technical staff to the clinic. The facility is under 24-hour security watch, and the individual treatment program takes about 3 months to 2 years, depending on the level of intoxication in the system. And where the judiciary comes in, and in Mombasa, we have the Shanzu Court where I preside, and then we have other courts, which includes the Mombasa law courts, which are within the jurisdiction of the Shimo-Latewa prison. And we refer the accused persons that come before us or convicted persons to the MAT services. And the referral can be done at any stage of the trial process, either at the plea stage, during trial, or upon conviction. And most of the accused persons who are the beneficiaries of the program are the drug users and not the traffickers. Instead of taking the drug user to prison for the offense of, for example, being in possession of narcotic drugs, the user is referred for rehabilitation instead of imposing an imprisonment sentence. And by doing this, we are meeting one of the objectives of sentencing, which is rehabilitation. And depending on the nature of the charges or the offense which has been committed, if an offender has to go to prison, the court makes an order to have the treatment done while in custody, and after the treatment is done, the accused person is thereafter released from custody. Where custodial sentence is not necessary, the accused person may be placed on probation sentence on condition that treatment is followed up. And this is also important because the probation officers are also counselors who take them through counseling sessions. And it's also part of the program that is run by the court. And it's important to know that treatment is voluntary and not compulsory. And in concluding, it's possible to fight and win the war against drug trafficking through drug treatment as an alternative to punishment and imprisonment. Because when we rehabilitate the drug users, narcotic drugs demands will go down, hence the traffickers will have no place to sell the narcotic drugs. Brief experience, but asanteni sana. Over to you. The name is difficult.
Asante sana, Ms. Macharia. It's thank you so much for bringing to life all of the intricacy and complex processes that need to be thought through, right, to make a program of alternatives a reality, but also the its great success. And thank you for underlying the fact that treatment is voluntary always and evidence-based, and that is the key to make this very much a success. Before I move forward to the next speaker, I just want to remind everybody that we are collecting questions and comments in the chat so that at the end of the presentation, we are already ready with a few questions to address, and we can use our time efficiently. We have had a wealth of experiences shared so far. More are waiting us. So please, if you have questions and comments, we really, really welcome them in the chat. Having said that, let's move forward. And it is my pleasure to present another experience from Africa. And in particular, Dr. Pelmos Mashabela. He is the Deputy Chairperson of the Central Drug Authority, and he will be presenting South Africa country level experience. Dr. Mashabela, the floor is very much yours.
Thank you very much, Giovanni. I'll try to see if I can share my presentation, and hopefully it is visible on, on everybody's platform. I'm not sure whether it is. I'm trying to see.
Not yet.
All right. Please pardon me.
We can see your screen, Dr. Mashabela.
Oh,
you just have to share it.
Okay. Are you able to see it or not?
Yes, we can see it.
Okay. Mm-hmm. Oh, thank you very much. Your Excellencies, distinguished guests, ladies and gentlemen, it is indeed a privilege and an honor for me to be, granted this opportunity to share with you the experiences of South Africa, particularly during this period, the pandemic COVID, and perhaps to share with you how we made attempts to deal with this global issue, this global challenge of alternative to conviction or punishment. Without further ado, let me just share with you how the interpretation goes insofar as South Africa is concerned related to the alternative to punishment. Now, it is common knowledge that the pandemic led to a whole lot of, and I think the UNODC rep, already pronounced on the fact that there was a joint statement regarding people who are incarcerated and those that are in closed settings, and prison being one of them. Now, it is in this that the President Cyril Ramaphosa of South Africa authorized that also in South Africa we need to consider placement on parole for the categories of sentence offenders, something that we call a special parole dispensation. Now, the act, legislation allows for the president, of course, to do that placement of offenders on supervision and or parole, but subject to certain conditions. So in this case, the conditions were purely stipulated as they are contained within the COVID measures and guided by the WHO. But also, I need to just pronounce that the Criminal Procedure Act, which is also another act that we use in terms of sentencing, permits that an alternative to imprisonment can be considered. But these kind of alternative sentencing options, such as your correctional supervision, such as your community service orders, have been in the statute book for years, but they are really not being used optimally. That's, we believe in, that's the problem. Now, in terms of the legislative framework, I've just, shared one or two of those, but then there are two alternatives to imprisonment that South Africa relies on. One is the correctional supervision and parole. Now, the minister, the Minister of Correctional Services is also empowered to refer to what we call a National Council on Correctional Services. If he's satisfied that there's a prison population is reaching such proportions that are, hampering the safety, the human dignity, and the physical care of the prisoners. So he can refer that, such cases for consideration for parole.
Dr.
Many
Rashid,
of these options, sorry.
I'm really, really sorry to interrupt. The participants are asking, could you please activate the slideshow? Because we can see your screen. You just need to put like on full screen so that they can see the whole slide.
Sorry about that.
No worries.
My apologies.
No
this
worries.
Is the new normal. I'm sure. I'm
right,
not sure whether
absolutely. Yes. Now we can see. It's perfect. Thank you.
Okay. Thank you. The commissioner, that is the person that is also in charge of prisons, can also is empowered by the law to, without really going through the court, to convert the prison term to correctional supervision when an offender has been sentenced to a fine. But also we notice that is, generally not being used. So is the heads of the centers also possess some discretion to release offenders with sentence that is less than 2 years on parole. Now, let's just look at the situation regarding overcrowding reduction. Alternative imprisonment has been shown to be a primary tool to lower prison population. I think that's the global understanding of, what amongst other objectives it does. Now, an overcrowding strategy where levels of sentence offenders are managed is through the use of conversion of sentences, which is also applied, applicable within the legislation, release on parole, and we use the transfer between centers to optimally use the bed spaces. Now, overcrowding reduction in the country is important. We understand it from a clinical perspective as it affects the quality of oxygen circulation within the cells. Now, at a glance, I thought, let's just look at the statistics. I'll just show you how it looks throughout the country. We know that sentence offenders constitute in the country 70% of the total inmate population. So we've got two types of offenders within the inmate population. It's the sentenced and the unsentenced. Now, 70% of those are sentenced and 29% of those are unsentenced, which is quite an alarming figure for, in our view, 29%, almost 30% if you like. And of course, males comprise 90% of those population, and females are, just hovering just less than 3%. Now, we've got 9 provinces. I'm not going to bore you with all that, but Gauteng, which is just in the Johannesburg, Pretoria area, accounts for 22%, in terms of the number of inmates that we have. And the Western Cape has got almost 18%, followed by KwaZulu-Natal. The Eastern Cape is the least province that has got offenders with 12%. Now, I've just given a demonstration of the total inmate population over 5 years. And you can see that in the 2018-19, which really overlaps into the COVID-19 year, we're sitting on around 162,000 inmates. This is a combination, remember, of both sentenced and unsentenced, as previously outlined. Now, for the last 5 years, there has been a steady increase and a little bit of an increase from 159 to 162 over the period of 5 years. I thought I could also share briefly a slide, just distribute just shows the gender distribution over 5 years. Now, if you look at the sentence on the extreme left of it's around females. And remember, I said there's both sentenced and unsentenced. Now, in 2015, just as an example, if you look at the females, there were about 3,000 females that were sentenced, and there's about 1,000 females that were unsentenced. Now, if you run through that figure all the way, you'll see that in 2018-19, the number of sentenced females has slightly reduced to 2,900, but the number of the unsentenced has increased to 1,300. Now, in other words, what I'm trying to demonstrate here is that you've got a steady increase of the unsentenced in terms of the females, whilst there is a little bit of a decline on the sentenced on the female. Hence, I was saying there's a concern related to unsentenced offenders, and I'm sure the alternative to conviction can come quite handy there. With regard to the male sentenced and the male unsentenced, also same trend. If you look at the 2014-15, there was about 103,000 male offenders that were sentenced, and in 2018-19, that has slightly reduced to 112,000. But if you look at the same trend regarding the unsentenced, in 2014-15, we're sitting on 42,000, and now in 2018-19, that number has also increased to 46,000. So the pattern is that there's a general increase regarding the unsentenced offenders, even if there's a slight decline regarding the sentenced inmates, which is a concern. I'm not gonna go into details there, but I just want to confirm that because of the issues around the Tokyo rules, the country then uses the following options with regard to alternative incarceration. There's a committal to an institution, there's fines, community service orders, correctional supervision, caution and discharge, compensatory orders, suspended sentences. And I must also then say, quickly hasten to say, there's very little data with regard to the other options, except for those that are more in the facilities. Now, in regard to why is it then that we've got the kind of sentence that we are using at the moment, is that you'll remember that, I just want to share that in the country, we have what we call the minimum sentencing policy. These mandatory sentences have been part of the country's penal landscape for many years. Here, the law provides for minimum sentences of imprisonment for a relatively small range of serious offenses. Now, this we want to believe is one of the reasons that really contributes to the high numbers of offenders, that some of them would have been considered for a different kind of consideration. Now, let's just look at the dispensation that we're talking about with regard to the release for offenders. In the country, we've got 53 parole boards, and it is these parole boards that were required in terms of the presidential provision to process 19,000 offenders for the special parole dispensation. Now, This was in response to the COVID pandemic. And these apply to low-risk sentence offenders, most of whom have passed their minimum detention period or approach their period in the next 5 years. So there was a criteria that was robustly built in, but in the main, that criteria was built using the WHO guidelines. But they included, amongst others, elderly offenders and those that have got chronic illnesses or other comorbidities, including pregnant women and women with children. Now, I just want to confirm that as at August, there were almost 45% of those that were already released from the 19,000. Of course, that was at the beginning of August, and remember the releases are happening on a daily basis. So we're monitoring the number of releases on a daily basis, and we're trying to build a database which can actually give us a sense of how many have been released on a daily basis to a point where we reach the 19,000. This was only in relation to the release as a result of COVID, because there are other releases that are happening on a daily basis. How does this then relate to the National Drug Master Plan? Within the National Drug Master Plan, which is also another 5-year plan that we have given to Parliament, is that we have already built in an objective that encourages the development, the adoption, and the implementation of alternative measures to conviction or punishment. So this is going to be one of the areas for which Department of Correctional Service and Justice are going to account on how have they developed and implemented these alternative measures. And we feel that is a very positive move towards ensuring that we are able to deal with the alternative to incarceration. And of course, to enhance access to treatment of the substance use disorders for those incarcerated and promote effective oversight. Now, there was just recently on the 31st of July, just to share with the distinguished delegates, there was a High Court ruling that in relation to children that actually proposed that the use and or possession of cannabis by children should not be criminalized. They may be sent to treatment facilities without a criminal record to their names. So no child may be arrested or prosecuted and or diverted for possession and use of cannabis. This we believe is congruent with the rise of the child regime. And I think it is a step in the right direction to try to say users of drugs should really be treated differently, as part of this rule. So we welcome it at the moment. Now, this to us, we believe that is part of the human rights for people who use drugs. The rights of the homeless during the COVID, the people using drugs and people who inject drugs and their dignity were protected during the pandemic. We in the major cities, for example, of the country, there was a comprehensive health services where 2,300 homeless people were brought into shelters and they were given food on a daily basis. The existing OST clients were placed onto weekly take-home doses, and there were about 1,200 people who were initiated into the methadone treatment, which we believe is quite a step in the right direction. Now, in regard to the victim offender mediation, we also want to confirm that in terms of the parole policy, the complainants have the right to be informed, the right to make representation when placement of an offender on parole or correctional supervision is being considered and be informed of the date. This is partly the reason why, as at the end of August, we are still, we are just hovering below 50%, because you can imagine 19,000 and the number of victims that needs to be involved into all these processes to ensure that we are on board. Now, just on the social reintegration matters, as they are going to be released, most of them are going to be released in conditions. And one of the issues that I need to share with you is that we are currently having 218 community correction offices nationally, which serve to monitor the compliance with conditions of release by offenders. All probationers and parolees are monitored by the correctional officials within their communities. But it's important we believe that it's important to partner with civil society and community structures for the continued public health services for those offenders who were undergoing the treatment within facility. There are a few things that we thought we could suggest in terms of the enhancing the discussion is that, one, in a country, there's still an empirical examination of the criminal justice system in sentencing so that incarceration does not become the only option for all crimes, because that's we believe is currently being the trend. The criminal justice system must focus on crime prevention, the reduced high use of incarceration, and the greater use of alternative sentencing. There's an issue regarding the reliability of data, which is not readily available on recidivism rates of the offenders that are placed under correctional supervision, those who receive drug treatment within communities. Research suggests that there's a lack of public understanding surrounding this non-custodial sentence in general. Now, this is one of the criticisms that we also confronted with over the past two decades. There's a steady increase of the unsentenced or awaiting trial detainees amongst women, and we request some in-depth study to determine the better use of alternative sentencing in relation to women and those that commit lesser serious crimes. That, in a nutshell, concludes my presentation in regard to the experiences of South Africa during COVID. Thank you very much, Giovanni. I hand back to you.
Thank you, Dr. Mashabela. It was a real pleasure to listen to your experience. And one thing that I particularly appreciated was the step in the right direction with regard to children, right? Which is an example that we should, of best practice that we should disseminate throughout the world. And something also that not only you, but many of the other speakers highlighted, which I haven't highlighted so far, which is the attention to the issue of gender and how this situation affects different genders differently. I really, I appreciated all of your presentation, of course, but this is what particularly resonated with me. And to give me just 1 second, I would like now to present the next country experience. We go over the ocean right now because we are going to hear a Caribbean perspective. And it is my pleasure to introduce the Honorable Justice Malcolm Holdip. He is High Court Judge of the Appeal Court of the Judiciary of Trinidad and Tobago. Justice Holdip, the floor is yours.
Are you all hearing and seeing me?
We are hearing you and seeing you now.
Okay then, very good, because the host had deleted me from the video presentations before. So
you're here now.
Good afternoon and good evening to all you colleagues and excellencies. It's the pleasure indeed to present the perspective from the Caribbean. Now, I am going to approach my presentation from the point of view of two particular areas of diversion which we have enacted in our country and also in the wider Caribbean. I will first address my mind to the drug treatment courts and thereafter to the bail supervision program. So first of all, if I may be allowed to speak to the drug treatment courts. You can move the slide on for the care of the others. Okay. Now, you need to be aware that the drug treatment courts have been enacted in Jamaica, Barbados, Guyana, Cayman Islands, and my very own country. The effect is that these courts have revolutionized our criminal justice system. We have moved away from the traditional legal system whereby an offender, once he had been arrested, he was just shunted into the traditional system and incarceration was the norm. Sometimes a fine, but incarceration. This program is one in which we are now going to be placing non-violent drug offenders into intensive court supervised drug treatment. And the stress is the word intensive court supervised treatment. So it alerts you to immediately the fact that whether it is a magistrate or a judge who is in charge, the court has the ultimate right of supervision. Drug treatment courts in the Caribbean target not only first offenders, but also habitual offenders. They all aim to reduce drug use and crime. It is not a soft option. If a participant fails to complete treatment, prosecution and sentencing would proceed routinely. Next slide. Now, within the context of the Caribbean, we have 2 drug treatment courts in Trinidad. There's one in Barbados, one in the Cayman Islands. There's now one in Guyana, and the progenitor of drug treatment courts in Jamaica, they have 5. And all of these courts are meant to promote a greater use of structured alternatives
no, there is
to
no problem.
incarceration.
I think, no, there is no.
And it's for non-violent offenders. Now, this is very important because it means that generally it is going to be for those drug offenders who habitually commit crimes to support their drug dependency, and also those drug offenders who would in the past have been caught with small amounts of crime, of drugs, and more so marijuana. And in this regard, it should be noted that both in Jamaica and in Trinidad and Tobago, legislation was passed during the course of last year, which decriminalized the possession of marijuana of 30, I can speak to Trinidad, in which if you possess 30 grams or less, it is now becomes a ticketable offense, so that there's a decriminalization of possession or for possession of marijuana in small quantities for personal use. The immediate resultant effect when this happened was that we saw within the period of about a month, the release of 125 persons who were on remand awaiting trial for small possessions of marijuana. And the law had changed so that these persons effectively would no longer have been in breach of the law. Now, the DTCs, the drug treatment courts, they link the judicial system of judges, and when I say judges, I include magistrates, prosecutors, and defense attorneys to the social service providers. And here I'm talking about the probation officers and the treatment providers. Now, what happens when you have this link, what we are doing, is addressing the underlying causes that have led to a person's offense, to wit, drug dependency. We move on. Next slide. The DTCs are designed to supervise cases of drug-dependent offenders who must all agree voluntarily to participate in treatment for their substance abuse. It is most appropriate when you have offenders who have reached a stage of their drug addiction and who realize that they are part of the recycling process whereby they commit an offense, they go in prison, they are exposed to the same drugs that they had outside. 6 months later, they come back outside. Their drug dependency remains the same. They commit an offense. They're back before the courts. If this person becomes sufficiently highly motivated, they can always seek to tell the magistrate, the presiding magistrate or the judge, I would like to go over to the drug treatment court. The judiciary has tried its very best to ensure that in all courtrooms, there are posters, there are signage which speak to the fact that a person can seek to have his matter diverted from the traditional law court over to the drug treatment court. Now, offenders, because they are the ones coming into this new court system, which is a parallel court system, adjudicated by persons who are all volunteers. Everyone who is involved in our drug treatment courts are also professionals who give up their time, talent, and to allow the drug treatment courts to function. Now, the participants must conform to the programs which have been set down by the court and the team of the drug treatment court team. Failure to do so means that it amounts to non-compliance, and you are simply, after there's a hearing, you are sent back to the traditional court system for sentencing. What is wonderful about the drug treatment court is that there's a structured system of incentives and sanctions to support compliance with the requirements of the court. Please note, before we go to the next slide, that like the South African brother had said, we too have a specialized division of the High Court, which is devoted to the family and children. The Children's Court deals with all children under 18 years of age with its own specialized rules. And the idea is that this court system seeks not to criminalize children. It has its own division of the Children's Drug Treatment Court, and they have their own rules and supervisions. This court, or these courts, there are two, are managed by masters of the court and judges of the court. So at the very highest level, you have this judicial supervision taking place. Another project which was started here in Trinidad and Tobago some 8 years ago is the Bail Boys Project, as it was initially known. But now, because it is now politically correct to rename it the Bail Supervision Project. It is a pre-trial diversion using bail and intensive, see that word comes up again, probation supervision. So that while the charge and the trial remain on the books, there's an opportunity for human development and citizen security. Because the Bail Supervision Court offers an opportunity for change under, of course, those certain conditions for those who would otherwise be incarcerated in pretrial delays. It had come to our notice that many young men had in fact been granted bail, but they could not access the bail. And so they would remain incarcerated in pre-trial detention for as many as 2 to 3 years, some even longer. And the situation was that it contributed to the swelling of the numbers within our prison system. It was also noticed that many of these young persons, when they got bail and they came out, they would attend court, and because of the delays, the systemic delays in our judicial system, their matters would not come on for anything from 3 up to maybe even 10 years. So as a result, they would just be coming to court, floating in and out of the court just to present themselves in person, to say, yes, I'm here, I'm still waiting for my matter to come on. The bail supervision now gives, as I said, those persons an opportunity to have a new change in their life. Let's look at the bail supervision project. Continuing. Now, under the bail supervision project, a magistrate or a judge, very often a judge, will be the one who will deal with the issue of bail for an offender before the court. And realizing that the person has in fact, whether he's a first offender or otherwise, he has in fact been incarcerated for a while will give due consideration to easing up the bail requirements to allow that person, if they say that they are going to join the bail supervision project, then they are able to access bail more easily. When they come, when that happens, certain conditions are of course set. Some of the conditions would be for the imposition of drug testing, regular drug testing, to ensure that they realize that coming out of prison doesn't simply mean that they go back to their old ways. We also impose nighttime curfews from like about 9 p.m. to 5 a.m. next morning. We insist that those who have the educational ability that they should attend classes, and with the help of the probation officers, we get them to enhance their academic and in some cases their vocational skills training. Very often, again, through the probation officer, or if at times we get a specialized person or a specialist person, there is talk therapy, which is designed to elicit a response and to develop the capacity of the participant to respond to obligations and responsibilities. Continuing, having observed many young men, and in this case now, as I said, women are now involved in the program, that while on remand especially, they were not exposed to any educational, vocational, or behavior modification program. The bail supervision project now is formulated in such a way that we can achieve some of the following objectives. And principally, we try through the court teams to expose young persons to structured programs, which will be geared towards the specific needs of that individual. Sometimes it's as a simple thing as letting them know that because they are incarcerated for this offense, it doesn't mean that that's the end of the world. We try to give them some sort of humanistic view of the future whereby they don't have to see themselves as being the black sheep of the society. We try to prepare young persons for eventual reintegration back into society. Simple things like getting their identification card, getting a passport, in some cases encouraging them to go and get a driver's permit, all means of better identification of themselves. And principally, if we could get them to get a job, we try to encourage them to open a thing like a bank account through a credit union or through a bank. All this is to try to maintain that the person does not become a recidivist. Continuing. Now, this court was implemented notably as a responsive court. This program, like the DTC, uses a graduated approach of rewards and sanctions, and participants meet monthly so that they can be reviewed. Supervision for participants is provided through the probation services with further monitoring by the community policing department. Here's where it's key and what we started to talk about the pandemic just now. Participants are required to attend court monthly, report to the police stations at least twice a week as ordered. And sometimes, as I said, they are placed on the curfews. Now, part of this is that the probation department plays an extensive role in ensuring that there's continued contact between these participants and their guardians and or other family members. What has happened as a result of or should I say, one should realize that the court was one in which there was this requirement, and I believe there's still this requirement of face-to-face personal contact, where you needed that human interaction to try to find out what was happening with these young persons in their lives that brought them in contact with the law and have them been at risk and found themselves incarcerated. And now you want to move them away from that. Let us look at what has happened as a result of COVID-19. Since, next slide, since March of this year, all our courts, that is the High Court and Magistrates Courts, have closed their court doors to visitors. And when I say so, I mean, unless it is a matter of urgency, and that could only be determined by the registrar of the court, then and only then are we having persons come into court. I use the word visitors. I should say litigants, because you are still able to visit the court if you have other business to do there. But in terms of visitors, even that has been reduced as a result of our lockdown situation because of the number of persons. The community spread of COVID-19 is quite high in this country. We have at present over 2,000 active cases, and so far to date, 58 deaths since this COVID has struck our country. Our hearings are now done virtually. The courts are seeking to balance public safety and the safety of its workers against the constitutional rights of citizens, especially when we have to deal with matters of a speedy trial. Now, the slowdown and restrictions on court operations have had serious implications for people with immediate problems, including those who are incarcerated and awaiting trial. This very day, Thursday, the 17th of September, the prisoners in the remand section of 2 of our major prisons have indicated that they are going on a hunger strike with a view to complaining that their matters are not being heard as quickly as they would like. And again, this is all due to the COVID-19 restrictions, where matters now have to be dealt with virtually. We also have a backlog of cases which has been exacerbated by the present lockdown. Continuing, our courts therefore have been forced to modernize with unprecedented haste. With respect to the DTCs and bail supervision program, we have lost the physical and human touch element, which the face-to-face contact would have allowed. Many of the young persons are at that stratum of the society where they have no access to the technology, no hardware, no access in the form of laptops, electronic tablets, internet, or Wi-Fi access. In the DTCs, there has been a complete halt to home visits by probation officers and treatment providers. Outpatient counseling is now conducted over the telephone, and there's difficulty in motivating the participants. We are having a grave trouble in finding these participants now. And one can understand that they are using the opportunity to evade the sort of supervision which the court would have placed on them. The police no longer provide the necessary community involvement. They are considered frontline, first responders, and high-risk personnel. So they are in fact looking after their own safety and not going far beyond the bounds of their job descriptions. Continuing, we have lost many opportunities for educational improvement, vocational skills, employment. They have all been lost because the economy has contracted under the strict provisions enacted by the government. So our country at the moment, if I may give you an example, public servants, only 50% are going out to work. Bars are closed. By 7 o'clock in the evening, bars are closed. Restaurants are closed. Gyms are closed. Casinos are closed. public transportation is now limited to 65%. So you see what I'm saying in terms of how the pandemic restrictions have unfortunately fallen harshly on the economy and on society. The opportunity to improve social skills is lost. Homework centers are closed. Sporting activities, especially contact sports, have been stopped. There can be no gatherings of more than 5 persons, not even at church. With respect, therefore, it means that the DTC has had to suspend all new intakes, and referrals which were there have simply been waitlisted. What we have is a steering committee which works together with the court executive administration. And what we have been seeking to do is we are in the process of developing virtual processes to manage the activities which were previously conducted in person. We also are trying to determine any changes to the eligibility procedure. We have to consider update on all intake documents and to include all temporary changes to procedure and any additional information. Consider as well that the courts, as a court, we have had to deal with people who have been missing hearings, and they have been missing hearings because of illness, which may be genuine or which may be faked. Some people, many people are in quarantine, and for persons my age, many of the persons around my age are not coming out in public for fear of contracting COVID-19. So that the COVID-19, the pandemic, has had a very harsh impact on the Trinidad and Tobago society. And I don't think it is any different from any of the economies and nation states of my fellow Caribbean. And I believe that I have just given an overview of some of the problems which we are experiencing and some of the steps which we are trying to seek to ameliorate the problems that we are having. I thank you all very much for the opportunity to give a perspective from the Caribbean with respect to the topic under discussion. Thank you.
Thank you, Justice Holdip, and thank you for highlighting not only the difficulties, but also how, you know, alternatives is definitely not the soft option. There is a lot of work that goes into that, but it's worth it because it goes to the root causes of the issue. And that was something that resonated with me very, very much. We're a bit over time, but I think that I see many, many people still online, and I'm really happy about that, because we still have a great presentation of country-level experience from Latin America. And it is my honor to introduce Magistrate Gerardo Ruben Alfaro of the Criminal Cassation Chamber and Rector of Restorative Justice in the Judicial Power of Costa Rica. Magistrate Alfaro, the floor is yours.
Muy buen día. Señora Cisse Mariama Mohamed, directora del Departamento de Asuntos Sociales de la Comisión de la Unión Africana, al señor embajador Namm, secretario ejecutivo de la CICAD, a la señora Miwa Kato, directora de la División de Operaciones de la Oficina de Naciones Unidas contra la Droga y el Delito, a nuestros socios nacionales indispensables para la consolidación del procedimiento de tratamiento de drogas bajo supervisión judicial restaurativa, el Instituto Costarricense sobre Drogas y el Instituto sobre Alcoholismo y Farmacodependencia. A nuestra moderadora, doña Giovanna Campello, a los distinguidos y distinguidas colegas y autoridades con las que comparto el panel en este foro, y al amable público que nos acompaña todavía virtualmente. En estos momentos, donde alrededor del mundo nos encontramos todos y todas en circunstancias similares y con la necesidad de reinventarnos y de ser resilientes, es un honor compartir a la distancia desde el Poder Judicial de Costa Rica la experiencia que hemos tenido en relación con el procedimiento de tratamiento de drogas bajo supervisión judicial en tiempos de COVID-19. Podemos adelantar la proyección. Es importante contextualizar que Costa Rica es un país ubicado en Centroamérica con una extensión territorial de 51.100 kilómetros cuadrados y una población aproximada de un poco más de 5 millones de personas. En relación con la pandemia, al día 16 de septiembre de 2020, según los datos del Poder Ejecutivo, se reportan 59.516 casos confirmados, de los cuales 37.764 son casos activos, 21.752 se han recuperado y tenemos un total de 649 personas fallecidas, lamentablemente. Desde el Poder Ejecutivo, una de las estrategias en relación con el problema que nos ha provocado la pandemia ha sido categorizar el país según alertas. En alerta verde, en alerta amarilla, en alerta naranja y en alerta roja. Propiamente, desde el Poder Judicial, se realiza un trabajo desde la Comisión de Emergencias, comisión de la que formo parte, y desde donde se han dado una serie de propuestas sobre medidas de atención de los servicios de administración de justicia, según las alertas que ha declarado el Poder Ejecutivo. Estas propuestas fueron aprobadas por el órgano jerárquico de mayor entidad en el Poder Judicial, que es la Corte Plena, y las cuales voy a detallar rápidamente. En alerta amarilla, se busca el regreso a una nueva realidad, con una reapertura de servicios, con la reactivación de audiencias orales por medios tecnológicos y presenciales, siempre y cuando se respeten las medidas de aislamiento, las medidas de distanciamiento social, así como las normas de higiene y desinfección para la celebración de las audiencias. Las zonas en alerta naranja solo realizan servicios esenciales, fomentando el uso de la tecnología para realizar las audiencias de forma virtual. Alerta roja, lo cual todavía no hemos tenido ninguna zona en el país en alerta roja, significaría el cierre total del servicio con mínimos esenciales. Y la alerta verde, a la que esperamos prontamente volver, es la apertura normal de servicios. Ante este panorama, es importante mencionar que los lugares donde desarrollamos actualmente el procedimiento de drogas bajo supervisión judicial han alternado entre alerta amarilla y alerta naranja. Sin embargo, ante el compromiso de cada una de las personas que conforman cada uno de los equipos, tanto desde el ámbito judicial como del ámbito salud, los servicios se han brindado de forma ininterrumpida, ya que en justicia restaurativa se considera necesario tener una cercanía entre el evento delictivo asociado al consumo de drogas, el abordaje psicosocial y la resolución judicial, por lo que es indispensable continuar con la prestación del servicio para dar una respuesta adecuada y oportuna. Para ello, se desarrolló un protocolo de atención de modalidad virtual de asuntos de justicia restaurativa, lo cual permite que personas que poseen factores de riesgo puedan realizar las diligencias sin exponerse al contagio. Un poco voy a tratar cómo funciona o desde cuándo funciona en Costa Rica el tratamiento de drogas bajo supervisión judicial. Inició en el año 2013 en materia penal en los circuitos judiciales primero y tercero de San José, y en el año 2015 ampliamos al segundo de San José y al circuito judicial de Heredia. Este procedimiento, desde sus orígenes, se desarrolla dentro del procedimiento de justicia restaurativa, mismo que se contempló en la ley número 9582, que entró en vigencia en enero de 2019, Ley de Justicia Restaurativa. A partir de este momento, se está en un proceso de ampliación paulatina para lograr la cobertura a nivel nacional. Al estar enmarcado el procedimiento de tratamiento de drogas bajo supervisión judicial dentro de justicia restaurativa, se trata de un abordaje interdisciplinario que desde el Poder Judicial se brinda con la participación de la persona fiscal, la defensa técnica, el equipo psicosocial y la persona juzgadora, con el apoyo del componente salud a cargo de un equipo interdisciplinario del Instituto de Alcoholismo y Farmacodependencia, que está conformado por un médico general y una persona profesional en psicología y otra en trabajo social, sin dejar de lado las organizaciones civiles sin fines de lucro que brindan tratamiento a personas consumidoras de drogas. Desde el ingreso del asunto a la Oficina de Justicia Restaurativa hasta la realización de la reunión restaurativa y la resolución de la persona juzgadora que impone la salida alterna de conciliación o suspensión de proceso a prueba, tenemos el plazo de 1 mes. La cercanía entre el inicio del abordaje integral y la resolución permiten tomar las acciones más adecuadas para la reparación del daño a la víctima, pero también para la recuperación de la persona ofensora con problemas de consumo de drogas. Sin olvidar que el contenido de la sanción o de la medida alterna debe ser proporcional a los hechos penales que se investigan. Posteriormente a la resolución judicial, durante el cumplimiento de las condiciones se tiene un seguimiento bajo el principio de alto apoyo y alto control, que conlleva una revisión periódica mes a mes de las condiciones a cumplir por parte de la persona imputada y una comunicación constante entre el equipo del Poder Judicial y del Instituto de Alcoholismo y Farmacodependencia. Son requisitos indispensables, podemos pasar la filmina, para la aplicación del procedimiento de tratamiento de drogas bajo supervisión judicial. Primero, que la comisión del ilícito debe estar asociado al consumo de drogas. Segundo, que la víctima debe dar su anuencia para llevar a cabo el proceso y no puede encontrarse en riesgo psicológico ni físico, evitando además la revictimización. La persona imputada debe estar anuente a llevar a cabo el proceso judicial bajo la modalidad restaurativa, aceptando el daño causado y siendo parte de la solución para repararlo. Y además cumplir con el programa de tratamiento desde el componente de salud. Y por último, se requiere del criterio técnico del componente de salud que permita la viabilidad del proceso de tratamiento. El procedimiento se puede aplicar como una salida alterna, ya sea conciliación o suspensión del proceso a prueba, o bien como una pena alternativa, siempre que se cumplan los requisitos de admisibilidad legal. Y tenemos entonces requisitos para que se dé la salida alterna de suspensión del procedimiento a prueba o de conciliación. Seguimos con la próxima filmina. O también tenemos requisitos distintos cuando se trata de una pena alternativa. Siguiente filmina. En el caso de la pena alternativa, esta está contemplada en el artículo 53 del Código Penal, 53 ter del Código Penal, y los requisitos están establecidos en el artículo 14, inciso C, de la Ley de Justicia Restaurativa. En relación con las salidas alternas, la suspensión del proceso a prueba en el artículo 25 del Código Procesal Penal y la conciliación en el artículo 36 del Código Procesal Penal. Conforme nuestra legislación, no es procedente justicia restaurativa y consecuentemente tampoco se podría el tratamiento de drogas bajo supervisión judicial en los delitos de carácter sexual, en los delitos sancionados en la ley de penalización de la violencia contra las mujeres, tampoco en las infracciones penales a la ley sobre estupefacientes, sustancias psicotrópicas, drogas de uso no autorizado, y tampoco en crimen organizado y trata de personas. Podemos continuar con la siguiente filmina. Es muy importante, la siguiente por favor. Es muy importante destacar que esta pandemia provocó cierres parciales y ha provocado restricciones en el ejercicio normal del trabajo de marzo hacia acá, de marzo a la fecha. Sin embargo, a pesar de ello, en las oficinas en donde aplicamos el tratamiento de drogas bajo supervisión judicial, en este año, entre enero y agosto, hemos tramitado 112 casos, de los cuales 35 han finalizado satisfactoriamente, 10 se han revocado y 67 se mantienen activos. En el entendido de que este procedimiento, como ya les indiqué, únicamente funciona en circuitos del casco central de Costa Rica. Digamos, en los circuitos judiciales de la capital, primero, segundo y tercero, y en el circuito judicial de Heredia. No hemos logrado extenderlo al resto del país. Es importante tener presente que los niveles de satisfacción de la población, de acuerdo con estudios que se han realizado, llega al 96% de satisfacción de las personas usuarias. Podemos continuar. Para finalizar, quisiera compartir, en resumen, una de las muchas historias de nuestras personas usuarias y que nos motivan a continuar con la ruptura del paradigma de un proceso sancionador a uno restaurativo para una justicia integral. En este caso, vamos a presentar con un nombre ficticio la historia de Luis. Podemos continuar con la siguiente filmina. La persona usuaria cometió un delito para comprar y consumir drogas. Ingresó a justicia restaurativa bajo el procedimiento de tratamiento de drogas bajo supervisión judicial y tuvo la oportunidad de reparar el daño y además tratar su problema de consumo de drogas y estudiar. Ahora, la persona no consume, encontró trabajo y cambió su vida, la de su familia y la de su comunidad. Desde el procedimiento de tratamiento de drogas bajo supervisión judicial, seguimos trabajando en tiempos de pandemia, innovando para no dejar de brindar el servicio que las personas usuarias requieren desde la administración de justicia y desde la salud, para así continuar repitiendo historias como la de Luis que acabo de mencionar. Desde Costa Rica, me despido con un fuerte y caluroso saludo de esperanza, con la firme convicción de que pronto pasaremos estos tiempos de dificultad, que nos harán más fuertes y que como humanidad saldremos adelante como lo hemos hecho una y otra vez en distintos momentos de la historia. Paz y bien para todos. Muchas gracias.
Thank you so much, Magistrado Alfaro, for your inspiring final words, but they were preceded by a very rich presentation on restorative justice. Thank you so much. You know, we have still more than 170 people listening to you, so I'm very, very happy that your experience is also being disseminated worldwide. I will now give the floor to my colleague, Anya. She has been collecting the questions from the chat. Because we are already a bit over time, we will not be able to take all of the questions, but she will take a few and assign them to some of the panelists so that we can address at least the most urgent question for clarification. Anya, the floor is yours.
Thank you so much, Giovanna. And just also let me say, I mean, what an amazing panel. I mean, this has been really such a learning experience, I think, for all of us. The first question which we had in the channel is to Madame Florence from Kenya. And the question to you is, In cases when people that come in contact with the criminal justice system are not only there because they're using drugs, but also they have been trafficking drugs. So how would you approach that within the legal system?
Maybe we do them all, Anya.
Sure.
You say them all and then we get the answers.
Sure.
So that we know more or less how many they are and people can also prepare accordingly.
Yes, and let's see if then we actually have time to do them all. I've been taking notes and we have quite a number. So that was one question to you. The second question maybe would also be going to Madame Florence, but in reality is to all speakers. So the question is that sometimes there are people that are going through alternative measures, but the community, so to say, is not very understanding. And it's actually the community that takes hard measures and is persecuting or beating the person with drug use disorder in that alternative program. And the question to all speakers, but I thought maybe Madame Florence, you also want to respond to that, is what's the way forward with regard to that? Yeah. And then we had a third question, which was highlighting the issue to some extent of livelihoods, sustainable livelihoods, and making a link to maybe including agricultural programs in either community service orders or in bail supervision programs. And that question seemed to be addressed both to Dr. Mashabela from South Africa, as well as Justice Holdip from the Caribbean. So the question on sustainable livelihoods, possible inclusion of agricultural programs. Then there is an additional, and I think actually we have quite a number of questions that are going to South Africa, but one of them kind of is with regard to the program that you have presented working with children, offering alternatives for children that have come in contact because they were also drug offenders or and so the question is first, what's the age category when you're talking about children in such programs? And then also what kind of interventions are there so that children actually do not go back to using drugs after they have been in contact with the services? And also with regard to these children, what are they using? Are there other substances other than marijuana? And the person who has asked the question is from Nigeria and says that there is, for example, tramadol and codeine. So we actually do have more questions, but maybe we take a break after those and then have a look at the other pending ones. And maybe this has given actually the presenters a little bit of time to prepare for a response or to think of a response. So if I'd like to ask Madame Florence Macharia from Kenya, are you still there with us? And would you take the first question on people that are both using drugs and trafficking drugs?
Okay, thank you. How we deal with the drug traffickers and at the same time they are users. First of all, it's very hard to get a trafficker who is a user. You know, the traffickers are in this business to make money and they use the users to make the money. So whenever we have the traffickers, they are charged with a felony because it's a felony. And we usually spend a lot of time because you find them getting to hire the best of the legal representation because they have the money. And they use all the delaying tactics to make sure, because the penalties are steep, they don't want to have the matters concluded very fast. In Shanzu, what we do with the drug trafficking cases, we've come up with a way of fast-tracking the hearings, where we hear the cases on day-to-day basis, even if it means denying them the bonds, because when they're in custody, the matters will go faster. But when it comes to the users, those are the cases that we apply the diversion and we take the plea bargaining and we put them in the MAT programs. But for drug traffickers, I've not come across any drug trafficker who is a user. That is one. And on the community, how they deal with the alternative justice systems. In ordinary communities, they believe when you go to court, you are going for punishment. But we've been having programs where we are educating the members of public, and we do so through court users committees. This is where we have several justice actors in a committee in every court, and we disseminate the issues that come to us, to the members of public, and we do so through public barazas. Public barazas are meetings where we use the local administration to reach that citizen at his place, at the village. And doing so, we see the community appreciating the alternative justice systems. And we also involve them to be part of the solution. And in the alternative justice system, where we use the elders, we use the community leaders,
Florence, we lost you.
Yeah, I think.
No. Florence, can you hear us? Now we can, I think. Say something.
Okay, what I was saying, for drug traffickers, we treat them differently. And whenever we are sentencing, we sentence them with the objective of deterrence. But for the users, we treat them with the objective of rehabilitating them. Because it's very hard to see a drug trafficker and a user in one.
Thank you.
The drug traffickers are there on top and the users are at the bottom, and they are the majority.
Thank you, Florence. Very, very interesting, and also the proactive work with the communities. Anya, I forgot the question, so I need to ask you to step in.
There was another question more around sustainable livelihoods and even maybe agricultural programs to be included in bail or service order programs like you have in South Africa, or also what was mentioned in the Caribbean.
There was more of a suggestion, right?
Kind of, yeah.
And what was there was a possible suggestion for improving the programs. There was an additional, yes, the question for our South African panelists on with asking for more details on the on children. Do we still have?
Oh, yes.
The good doctor online?
Yes.
Yes, I see you. I see you.
Oh, okay. No, there's just.
Yeah.
Well, one, in terms of the children, because there's a question as to the age.
Yes.
I just want to confirm that in terms of the legislation as we have it now, is that we are looking at, those that are 18 years and below. So those are defined within the child.
As per international law.
Yes. So anybody who's 18 and below and is committing a drug-related offense as per the judgment, yes, those are, we're not even talking diversion. They just have to be sent straight for treatment with regard to drug use. So that's in terms of the, but for the food security, I don't want to belabor the point, but what we want to confirm is we're currently investigating because we profile all the parolees and the probationers. We want to investigate an opportunity of making use of them within the food security environment, such as your agricultural environment. But we want to juxtapose that with the victims of the crime, so that you've got the combination of parolees and or probationers supporting the victims, but also also victims participating within the food security environment. This is in line with profiling the skills that offenders acquire within the facility and how to link them with the economic opportunities. So we do have a whole database of what kind of skills do the offenders leave when they get released on parole. And that skill is the one that we want to link with the market out there. So I hope I have covered the two comments. If not, I'm available to even put it on the chat line. Thank you very much, Giovanna.
You did very well, but if you want to add something in the chat line, of course, you're super welcome. Anya, you said there were other maybe questions?
Yes, there was, for example, one question to Justice Holder, where somebody was asking that you mentioned in your presentation that there is no criminal charge apparently for possession of marijuana under a certain threshold, I think 30 grams or so. But the question is, what would be the punishment for serial offenders or for repeated offenders, let's say, if that would change the situation?
Okay, once it is under 30 grams, no criminal offense is committed. So they basically you are warned you're warned if it happens in public. But even at home, one is allowed to have as many as 4 marijuana trees without inviting the police, inviting the criminal section. However, if it is that you are charged for trafficking in drugs, we have increased the fines to as high as $3 million TT. So it gets a very strong deterrent factor for those who are caught in the process of trafficking of drugs. But as I said, the decriminalization process is such that it even allows you to have as many as 4 trees per person per household, so that you really and truly, you hear very little of persons being arrested for possession of marijuana again. Of course, possession of harder drugs such as cocaine, ecstasy and all those sorts of drugs, those still remain very serious offenses and they are not decriminalized. What has been decriminalized is the use of marijuana. And as I said, once you are less than 30 grams, which is equivalent to like about 2 packs of marijuana cigarettes, there's no criminal offenses committed. I hope that answers the question.
Thank you very much for the clarification. We've also had one question to all panelists, but maybe I can ask Magistrate Ruben Alfaro from Costa Rica, because you have mentioned how you're in your restorative justice programs are also working with different community counterparts. So there is a question, how can the religious sector play a role in implementing alternatives to conviction or punishment?
Muchas gracias. En realidad, justicia restaurativa y el procedimiento de tratamiento de drogas bajo supervisión judicial tienen un componente importantísimo que es el componente comunidad. Entonces, nosotros trabajamos con una red de apoyo comunitario que trabaja con nosotros el seguimiento del acuerdo restaurativo. Y en este componente comunidad, pues estamos anuentes siempre a recibir todo tipo de organización. Y dentro de ellas, en Costa Rica, han sido muy importantes las diferentes denominaciones religiosas como organización que nos han mostrado su apoyo para el seguimiento de esos acuerdos restaurativos. Entonces, no es en relación con una afiliación religiosa en específico, sino con una organización con la que tiene una determinada afiliación religiosa, y nosotros pues trabajamos con ellos como trabajamos con cualquier otra organización comunitaria que nos permita el cumplimiento de las metas de justicia restaurativa. Muchas gracias.
Wonderful. Thank you so very much also for this response. I'm kind of coming to an end to the questions I had written down till we opened for Q&A. There was maybe one more comment, and one question was there, Jean-Marie, that was kind of to you, but maybe you also want to defer it to any of the other panelists. So apparently you mentioned in your presentation that there is a high number of early releases and pardons that you have observed. And the question is if those would have a negative impact on the morale of law enforcement services. If you have heard anything like that, or maybe one of the practitioners or experts who were here with us on panel would like to comment also. The question was to you, Jean-Marie.
Thank you, Anya, and thank you to the questioner for that very pertinent question that I'm also struggling with. I cannot purport to talk on behalf of any of the referenced member states. Perhaps one of the panelists can also respond to this, but I can only imagine that here we are looking at a situation of balancing between public safety in the spirit of upholding public good, safety, and dignity, and keeping people in prison. So what's the better of the evils? And when I listened to the justice from Kenya, Macharia, speaking, and also Dr. Pelmoth, it has to do a lot with the preparation of the community so that justice is also seen to be done. And remember in my presentation, I also talked about limited viable treatment options. Are they available so that when these people were released, if it's conditional release, then they have to comply with certain requirements. So I'm only imagining that as they do this, and because it's COVID-19 situation, it must be emergency, but I'm imagining that those that have been released are those that do not possess any public risks to the community. And I'm imagining that part of the conditional release would be reintegration. And some of the challenges that I talked about earlier on, limited treatment options, weak linkages for economic and social reintegration, that obviously we need to be looking at moving forward beyond the emergency measures of COVID-19. But perhaps one of the panelists might wish to speak specifically to this, where they employ it and whether it really compromises justice. Thank you. Anya. Over to you.
Ms. Anja, you're muted.
Sorry. Maybe if there is any of the other panelists who would like to comment, if you have observed that early releases or parole program would have any, in the question, it was negative effect on the morale of law enforcement services. Have you observed this? Have you maybe even observed the contrary? Anybody would like to comment on this from the panelists? But I think we've also already heard from Jean-Marie, and maybe then, you know, as nobody is sharing, I assume maybe there are not so many of these negative kind of perceptions. And as said, I mean, law enforcement can be very much be made part of the progress. So maybe there is one comment and one question in the chat, which maybe we can really use to wrap up. And as people are still writing comments and questions, you know, try to reach out to us maybe also afterwards. I think we're all here to help and support. And maybe in that sense, also to mention one of the comments that was really saying how much, you know, we need this the synergy, right, between the efforts made in the justice system and all of what we heard, and making use of the alternatives that are there, looking into the establishment of new ways in the justice system, but at the same time really make this investment in providing treatment and care services to address negative health and social consequences of drug use in the communities, so that there is really a good system, and they are working together, and the justice system actually also has a place to refer to in the community. And that came up also in one of the comments, so thanks for that. And then there was a question actually, maybe addressed to all panelists, if there are, let's say, plans or strategies to assist additional countries in this perspective that people who use drugs are not criminals, but those that actually need a health response. And I think that, and I see Giovanna is back, for then we can go to the closing, but I think that, you know, from all the organizations, likely we can say that, you know, we are here in these two regions and also beyond to support all member states in their efforts to implement treatment as an alternative to conviction or punishment, and help bringing together actors in the public health system with actors in the justice system. So your question is very well heard, and, you know, in principle we are there for you. Reach out to us also with additional questions. I think we are okay with Q&A, Giovanna.
Okay, thank you. And sorry for missing a little bit of the Q&A, but I got a phone call from the director that I needed to attend to. And well, it is my great honor, even having missed this last room.
Excuse me.
Yes,
Giovanna,
please. Yes.
Yeah, if you don't mind, yeah. Could I just make a quick announcement, please, before you close?
Of course. Please.
Okay. Okay.
You have the floor.
Thank you. There's a question that was asked related to the role of traditional and cultural leaders.
Mm-hmm.
It is an emerging topic in the continent, and to really provide a platform to discuss this, there's a series of webinars taking place at the moment, of which one of the themes would be on the role of the traditional leaders. A number of you may be aware that the International Society of Substance Use Professionals, CICAD, in collaboration with the African Union Commission, is organizing a series of drug demand reduction webinars that started yesterday and will end in November. On the 4th of November, will be dedicated to discussing the role of traditional and religious leaders. So I would encourage as many of you as possible to attend this webinar and participate and get to listen to know what's happening in our continent. And you can send you can make inquiry from the organizers, then we can send you the link to join that webinar on the 4th of November. Thank you very much. Over to you, Giovanna.
Thank you, Jean-Marie. Thank you so much. And actually, I would encourage you to join many other of the sessions of the conference that Jean-Marie and the colleagues at ISAP are organizing, because it's really packed full of interesting sessions on all sorts of topics on prevention and treatment and more. So thank you, Jean-Marie, and I am just issuing a small plea to my co-organizer to confirm that I can go for the closing. Yeah. So, well, don't worry, I will not keep you long. I don't want to be the woman standing between you and lunch or dinner and so on. But I will take just a couple of minutes to thank all of our panelists that have provided us an amazing wealth of experiences and being very honest with us with the challenges that they are facing, particularly in the context of COVID pandemic, but also in general. And I hope that they have inspired us all into bringing action forward in this field and learn from each other, as I certainly have learned myself during this couple of hours that we have been together. And I still haven't learned how you show appreciation for panelists online. I usually invite everybody to clap, you know, put their video on and clap at least a little bit, even if on mute, to really thank the people that have contributed so much. And let me thank, of course, the institutions that have been together with UNODC being here, CICAD and the African Union Commission, and the colleagues that have been here together to organize this and make this such a success. And last but not the least, the colleagues that have been worked tirelessly behind the scenes to make this a reality. And I will forget somebody for sure, but Pamela, Santiago, and Wataru on our side, together with Maria and Alfie and Anya, of course, and have been really at the forefront of pulling this together. So I would like to acknowledge their contribution, and please forgive me if I have forgotten somebody. And that's all. For the rest, I would like to thank you all for being with us for so long. And I hope you have found interest and inspiration as I have done. And do stay well, keep safe, and keep in contact, and let's make alternatives to incarceration and punishment for everybody, not only for people with drug use disorder, but also for people who use drugs and with drug use disorder. Let's make it a reality. Thank you so very much. Bye.
Thank you, Giovanna, for those very inspiring words. And to all of our participants, we're just going to launch a really quick evaluation poll. It's 60 seconds. So as you can see, it should be in your screens right now. We ask you to please go ahead and vote live. This evaluation allows us to look into, use it as feedback and improve for future webinars. So we really appreciate your input in rating us on a scale from 1 to 10, being 1 the lower and 10 the higher score. Please rate today's webinar. Again, your contributions are extremely valuable. The reason why we launched this webinars is for the public's, for to benefit the public. So we're extremely honored that you stuck around and listened to all of these wonderful experts. So as Giovanna said, thank you so much for everyone's participation. I will be closing the poll in 5, 4, 3, 2, 1. Thank you so much, everyone. Thank you so much, everyone, and thank you to all the participants. Until next time.